In this video I want to take a look at something that is specifically of concern to employers. Now, the title of my video is The Problem with Using HR Consultants for Legal Advice, and it arises out of a case involving a man in County Monaghan, Mr. Carron, against a company called Fastband. But I'll take a look at the problem and identify specifically what you need to be wary of if you are an employer right after this. Okay, the first thing you need to understand is that there's two types of privilege that might arise in a claim or in a litigation or in a legal action. One is legal advice privilege. So this is the privilege over communication made either to or by a lawyer during the course of a professional legal relationship with a client. So if, for example, you're an employer and you're my client, I'm going to give you a certain amount of advice. You may have a problem employee, and if you do, I'm going to tell you what the risks are in relation to terminating that employee's employment, what ways it might be possible with the minimum of risk or the minimum of cost to do so. But all of this advice is obviously going to be confidential between you and me. That's because we have what's called legal advice privilege. Excuse me. There was a case there last year or the year before involving the Employment Appeals Tribunal, in which they held that Mr. Carron, who was the claimant against Fastcom Broadband Limited, the legal advice privilege only applied to the lawyer and client relationship, and consultants or representative bodies or non-lawyers were not entitled to this privilege. Very, very briefly, Mr. Carron, as part of his claim for unfair dismissal, along with his solicitor, made a data protection request from the employer. And the data protection request under Section 4 of the Data Protection Act 1998 obliges the employer to give the employee all notes and records dealing with the employee. So when these records were handed over, the employee and his legal advisor, Mr. Brian Morgan from Monaghan, discovered that any advice that the employer was given by an employment consultant called Peninsula wasn't disclosed. And when the hearing came along in the Employment Appeals Tribunal, the employer and Peninsula claimed legal advice privilege. Mr. Morgan for Mr. Carron, the solicitor for Mr. Carron, objected to this on the basis that Peninsula were not entitled to this privilege, legal advice privilege, because they weren't lawyers, they weren't solicitors or barristers. They're employment consultants, and they are HR consultants. They do employ solicitors and barristers, but the question arose as to whether they were entitled to have this privilege, legal advice privilege, or not. And the Employment Appeals Tribunal found that they were not entitled to withhold this information from Mr. Carron. So this, as you know, for you as an employer, is going to pose you great problems, because essentially the advice that you would have received in relation to terminating an employee is going to have to be handed over to the employee and his legal advisor, because it's not privileged. Now, this case is under appeal to the Circuit Court, and I understand there's a similar case involving similar principles in the High Court. Nevertheless, it's a very, very important decision, because if you're an employer and there's a risk or a prospect of an employment claim, a legal cause of action arising from your dismissal or termination of an employee, then you need to consider where you get your legal advice, because if you get it from a HR consultant, then it's possible that it's not privileged and can be accessed by the employee by making a simple Section 4 data protection request. So that's one type of privilege. So what does this mean for employers? You as an employer. Firstly, the advice given by HR consultants to you as an employer may be available to a disgruntled employee once he makes a data protection request under Section 4 of the Data Protection Act. Other services provided by HR consultants would not be affected by this decision. So there's absolutely no difficulty in HR consultants providing various other services. But giving advice or giving legal advice in circumstances where there may well be an unfair dismissal claim or perhaps even legal proceedings for breach of contract, in that situation then the advice could well be considered to be legal advice and may not be privileged. The employee needs to consider carefully, or the employer rather, that should read employer, needs to consider carefully obtaining legal advice about an employment matter, especially one which may end up in litigation or a claim. The Karen case, as I say, Mr. Karen made a data protection request of his employer in preparation for the unfair dismissal claim. The request obliges the employer to give all records in electronic or paper form which mention the employee, that is, the data subject. FASCOM, in complying with this request, did not hand over the advice they received from Peninsula, the HR or employment law consultants. They claimed legal advice privilege. This was challenged by Mr. Karen and his solicitor. The EAT agreed with Mr. Karen and his solicitor, and they basically found that no privilege for Peninsula in respect of legal advice given to the employer arose because Peninsula are not lawyers, they're employment or HR consultants. There's a second type of privilege, that is litigation advice privilege. Litigation advice privilege is advice given by a lawyer to his client when preparing for litigation. The EAT in this case held that litigation advice privilege may apply to advice given by non-lawyers, for example consultants or representative bodies or advisors. Just to be clear about that, if litigation is in prospect or pending or in being, then the advice given by HR consultants or by Peninsula or anybody else would be privileged. It would attract the benefit of litigation advice privilege. But this would only apply to advice given after the employer has been notified of a claim and litigation is in being or pending. So everything up to that point, everything up to the point where the employee brings a claim would not be privileged because it would be legal advice privilege. It would not be litigation advice privilege because no litigation is in being or in prospect or contemplated. Litigation must be in prospect or pending in order to obtain litigation advice privilege. There is a thing called the dominant purpose test. The dominant purpose test is a very important test when it comes to claiming litigation privilege. If the documents were prepared which had as their dominant purpose dealing with the litigation, then they will have litigation privilege and will not have to be disclosed to the other side. However, if the dominant purpose for the advice or the preparation of documents is not the litigation, then those documents may have to be disclosed to the other side, which is going to sink your defence if you're an employer under the waterline, or may well, not necessarily, but may well seriously weaken your case and your defence. My name is Terry Gorry. My details are there on the screen, as you can see. If you like this video, if you find it useful, you might give it a thumbs up down below, and you might share it with somebody who you think might find it useful as well, and you might be interested in subscribing to my YouTube channel.